guys, welcome to the No State Project here at my YouTube channel, No State Project, live from the fortified compound in Mesa, Arizona. Glad to be with everyone today, and it was kind of touch and go there for a bit. Had a major tech issue, but didn't get it resolved until 2 minutes of the show, so we're here. We're kind of used to that. I also want to thank everyone for their continued support of the big show. We are only a few dozen subs away from getting 10K, the magic 10K, or at least that's what I hear. That's the kind of the magic number. So if you're not subbed, you won't be able to get notifications when we're going live. So or when we post new videos. Just I hate to be to do that, but we'd like to hit the 10K. Again, this is episode 48 of the big broadcast. I got a number of videos that I want to get posted. I'm going to finally get, hopefully by tomorrow morning, get the video for the Tyranny Spotlight on Stephen W. Myrie, who is the U.S. attorney guilty again. He is a serial offender of prosecutorial misconduct. And when he doesn't give you, there was one case that you'll have in there, I'll have in the video. It's going back about 8-9 years. U.S. versus Chapman. There was over 650 documents he didn't give. 650. So when this guy does prosecutorial misconduct, his thing is like, go big or go home. When he screws you, he's going to screw you good. And like I mentioned before, there's very little documentation available on this guy. I do have a picture of the guy when he used to have hair. So I'll have that in the video, so look forward to that. Remember, Libertopia 2018 is going to be in just a few months. That is May 3rd through May 6th in San Diego. Libertopia.org is how you sign up for that. I did, for those who were following the show, when I mentioned on Saturday's show, Bao is still in jail there in Tarrant County, Texas. And I did get information today that we do know he's going in for a psych evaluation today. Someone did get me the doctor's name. And I'm having trouble finding it. I did have it here. We do. All right, well, bottom line is, I'll find it. We'll have it linked in the video. We have the doctor's name. And this brings something up that I've mentioned before that we need to really do. I don't necessarily need to have an anarchist who's a psychologist do this. Because I think that's why I kind of lost steam on this before. Because it's starting to happen a little more than I like to see. And so maybe we have to make it a regular part of what we do here when we're going against these predators in court, and that we're starting to get more, still not a lot, but we're starting to see more of the psychological evaluations, which is just a tool to keep people from talking. It is the height of gaslighting. It is horrible. It's despicable. So we have this judge, Cheril Hardy, and we have a few more pictures, and we know a bit more about her. I'm going to be doing a separate video on her. So when you do a Google search, you will find pictures of her and what she did to Bao. And who knows how many other people she's done this to. But we need to get a psychologist or psychiatrist to issue a statement that questioning legal conclusions is not a basis for a psychological evaluation. That is no reason to question someone's sanity. So we can go in there right off the bat and say, sir, if you're going to try to order a psychological evaluation on me, we already have an official, we have a doctor's order or a psychologist statement here. Questioning legal conclusions is not grounds for a psychological exam, you son of a bitch, you. So hopefully we did. I did a habeas corpus to try to get him out, get Bao out. I sent it over to some friends on Monday. I don't know if it's been filed. I haven't heard back. Obviously, it's not stopping the psychological exam from going on. Oh, actually, I found it. It's 6 p.m. Central Time. So in an hour from now, he's going to be interviewed by Dr. Barry Norman. Now, I don't know. I'd like to call and talk to this guy or any of these doctors who have done these psychological exams, and if they know what the basis is. What grounds has the judge presented to this doctor, if any, of why Bao should have a psychological exam? This is the height of gaslighting people, not only threatening you with a psychological exam, but to actually carry it out. If you're not familiar with gaslighting, it comes from a 1940s movie, and it was actually done twice in the 40s. The Ingrid Bergman one is actually the remake. And I think that was Angela Lansbury's first role. So if you're, you know, it really is a fantastic movie. And the idea of gaslighting is to make someone feel like they're crazy just for questioning something or claiming something. So the idea that they would threaten Bao, me, or anyone else with a psychological exam merely for questioning a prosecutor's claim, wow. That's some serious gaslighting there, everybody. No doubt whatsoever about that. So we'll find more information about this Dr. Barry Norman and probably get that in the video with his accomplice there, Cheril Hardy. Because maybe it's just a money thing. He's just doing because it's easy money. And hopefully they are actually going to release him when they realize there's not a damn thing wrong. But I would certainly hit Tarrant County with a claim against their insurance, risk management, for this false imprisonment. And this Cheril Hardy, we have to do multiple. It should be multiple complaints to the Tarrant County Commissioners and the Bar Association about this is just sick. So a prosecutor makes a claim, hey, this court has jurisdiction because they're in Texas. And you come in and just question that. You want evidence to prove that that's true. That a claim against you is true. Hell without bond, psychological evaluation. Let me tell you something. The only one in this picture who needs a psychological evaluation is Cheril Hardy. And I believe I have a college picture of her. And if I do have the right woman, boy, you can really understand why this woman's got an axe to grind. It could not have been a happy childhood. Obviously, I mean, why else? I mean, my gosh, what's in this woman's past that she's going to order a psychological evaluation on someone for asking a question? Ay, ay, ay. So that's that. Hopefully, we get word real soon that Bao is actually out. But he is being held without bond. So we shall see. So let me see if we've got any of those calls. Oh, looks like we've got it lit up. Some new callers here. So let's go to area code 720. You're live on the No State Project. What's your name? Where you calling from?
My name's Alan. I'm calling from Denver.
What can we do for you today, Alan?
Yeah, so I had a lot of questions. I haven't got on the role play yet, but I am familiar with the guys' the Socratic method. I had one case in Denver, and I have two cases pending. They're carrying some criminal charges with them, but they're basically just traffic. And I filed all your motions and everything. The first case that I had in Denver, I ended up getting a little bit of jail time, 10 days, because they forced me into a trial, and I was kind of stuck. I was unprepared for trial, didn't know what to do.
Well, that's terrible.
Well, I ended up getting 10 days in jail. I got a driving under revocation thrown out, but they got me for obstruction and I believe disobeying a police officer. And I just didn't really know where to go in trial, but I did my time, whatever, and I was going to appeal it, but it's just so damn expensive. But anyway, I have these other two cases pending now, and I'm facing jail time on them as well because it's driving under revocation. And they're forcing me into trial again, and I'm not really sure on how to what to do for trial. On what points to argue. I know I've heard you say before about impeaching the witness, and I tried to do that, and I effed that all up. So, I mean, I just need some help, I guess, getting ready for trial.
Well, I'm glad you called about that. So hopefully, you know, you get better prepared. You can do better better in this next trial. I mean, the role playing is essential. I know some people may, you know, one person in particular on the chat will claim that all the success that I've posted, and he's not doubting we've had a lot of success because the evidence is pretty overwhelming. Only a real idiot would say that it's not, you know, that we have not had a lot of success. Only that he believes that it's not necessarily coming from doing the role playing, because he's discounting all of the pretrial and arraignment stuff, which leads to us getting a nolo prosequi, or where the prosecutor declines to prosecute. So,
right. So, in your opinion, do I even have a chance at a dismissal or whatever now that they're already forcing me into trial? Because the last time I went in, I attempted to use to try to get them to show me proof of you know, that their laws and stuff apply to me, and she basically she threw me out of her courtroom. She threatened me with contempt, had me escorted out of the courtroom, said I'm not allowed in her courtroom anymore, and threw me out before I knew any of my dates. I'm still kind of lost as far as when my trial dates are, because she threw me out, and this was just last week, so I haven't had a chance to find my actual dates. I know it's like a month down the road, though.
All right, Alan. So, have you filed a motion to dismiss and the discovery request already?
Yes, I have filed them, but
it's your audio is not too good, but it's getting the job done. So just all right. So you filed a motion to dismiss and the discovery request. What happened with that?
I actually filed all the motions because I wasn't aware of the, you know, how, in what order you're supposed to file them or anything. So I filed them all. The motion to Lamine also.
And you got them from me?
Yes, I got them all from you.
Well, in the email that I send, there's instructions on what's being filed and when. So, not that big a deal. It just makes it look like you don't know what you're doing. So,
which is exactly the case.
Okay, so was there a ruling on the motion?
I don't know. I mean, this last hearing was kind of a blur because she threw me out so fast, and I don't know if she ruled on them or not, or if I'm supposed to set a motions hearing before trial in order for her to rule on those. I don't know. Well, you can
certainly check the docket online. They should have something online where you can see if the judge has made a ruling on that motion to dismiss or not.
Okay.
Have you gotten discovery back from the prosecutor?
I did get a discovery, yes.
What did you get in response to the discovery as far as questioning whether the prosecution has a witness with personal first-hand knowledge that the Constitution and Code apply because you're physically in Denver?
I don't know if I got a response to that or not. I haven't went through the entire discovery, but it's mostly just the citation. There was a 911 call and stuff like that. The officers with a ticket, I guess.
Okay.
So I'm not sure exactly what I need to do next. I mean, I filed the motion. I'm not sure what I'm looking for, what I'm supposed to be waiting for or doing at this.
What you want to do is contact me off air, and I'll get you a template for the motion to dismiss for prosecutorial misconduct. So because the prosecutor is not providing the documents and the name of the witness with personal knowledge, or not disclosing that the witness doesn't have personal knowledge, then that's called a Brady request. And like I mentioned at the top of the show, like Stephen Myrie is really good for Brady violations. That is a cause for dismissal. It's unfair because they're supposed to be giving you exculpatory evidence. They're supposed to be giving you all evidence that they have that would show that you are not guilty or that you are innocent. And they have to give you any information that can be used to impeach their witnesses. Now, their witnesses have to have personal first-hand knowledge of the matters that they're testifying to. And the main matter that the police officer is testifying to is that you were physically in Denver. That meant the Constitution applied, and that gave him jurisdiction to investigate and give you a ticket. So, if he doesn't have personal first-hand knowledge of that, the rules don't permit him to testify. That is exculpatory information or impeachment information, rather, that the prosecution is required to give you, and not giving you that information it may constitute, if it's bad enough, a denial of a fair trial and grounds to be tossed out. So that is something that I would definitely get filed.
Okay.
And
okay, I'll file that right away. And
the fact that you haven't done the role playing, holy crap. I got to make this quick. The fact that you haven't been role playing is not a good sign. You definitely need to get a script and do some role playing. And I would also recommend getting in front of a sitting city council. It doesn't have to be for Denver, but it could be for, another smaller city outside the area, and question him on the issue of jurisdiction so that you can get your feet wet and have an easier time, be better prepared to go into court and do it for real against the judge.
I'll definitely do all that, and again, I will contact you after the show off there and try to ask you some more questions. I have a few more questions to run past you.
Okay, sounds good. I'll
let you get to your next callers, and I appreciate you getting me on the air. Thank you.
Not a problem. Appreciate the call. Alan in Denver. We've got another new call. I think this is Connecticut, but we've got area code 360. You're live on the No State Project. What's your name? Where are you calling from?
My name is Lewis Hughes. I'm calling from Washington State. I have a suggestion for your friend in psychological evaluation.
Okay.
In 2008, I had a federal judge order me to Federal Correctional Institute, Butner, North Carolina, for 4 months of psychological evaluation. What the poor judge didn't know was that I basically have a minor's degree in psychology, and I had a frickin' ball.
For 4 months?
For 4 months, I had a ball with a state-appointed psychologist because she didn't know which end was up because she had only had her license to practice for 6 months.
Well,
needless to say, it did not bode well for her.
Well, Lewis, what the hell happened that would cause the judge to do that and have you that's horrifying to me. I'd rather go to jail for 4 months or a year rather than to go 4 months for a psychological evaluation, and yet you're saying you had a good time. But so what prompted the judge to do this?
32-count federal indictment against me, and I refused to give the court jurisdiction.
Oh, Louis,
so obviously
Louis,
something was wrong with me if I wouldn't give them jurisdiction.
But okay, that doing what you were doing, I don't think is an effective way to defend ourselves because their jurisdiction doesn't. We could get to that. But
let me go on with your friend. Here's what I suggest you do. We've had good success with this in several cases. File a notice of lis pendens that you are going to sue the county, Tarrant County, and each of the commissioners in their personal capacity in Tarrant County in federal court under 14 Stat 27, the Civil Rights Act of 1866, not 42 U.S.C. 1863, Civil Rights Act of 68, because that doesn't, or 1968, that doesn't do anything for you.
Say that again. Give the citation.
Put it in an original jurisdiction.
Give the citation again.
14 Stat 27, Statute at Large, Volume 14, page 27, Civil Rights Act of 1866. Make sure you thoroughly understand what it's saying. It is not granting new rights. What it is doing, it is affirming the unalienable rights that were set forth in the Bill of Rights and in the Declaration of Independence.
Well, that would kind of conflict or contradict our position that the prosecution has no evidence proving that the Constitution and laws apply because we're physically in, let's say Denver. So by filing a suit like that, you're actually making a claim that you are protected and that the Constitution does apply to you. So that's a problem right there.
No, we're not bringing in the Constitution. We're bringing in the fact that Congress said you have certain unalienable rights that were originally set out in the Declaration of Independence. But the whole point is, when you hit them with a $25 million lawsuit, you just screwed up their money mill. You just made it difficult for them to borrow money or to go sell new bonds, things like that. That's what gets their attention. Hit them in the pocket.
Well, I certainly understand and appreciate wanting to hit them in the pocket, which is why I talk about the claims against their insurance, because there is no sovereign immunity that way. But to file but to file a $25 million federal suit, you most certainly are invoking the protection of the Constitution. You may have what's called unalienable rights, but you're claiming that they're protected by the Constitution. And so I see a flaw there.
No, we're not claiming they're protected by the Constitution. We're saying Congress affirmed that you have these unalienable rights. It's not tied to the Constitution. Go read the Civil Rights Act.
Well, I'm gonna I'll take a look at it, but I'm gonna still believe that when you're bringing such a civil rights claim or a claim of rights and damage, you're saying that they have damaged your rights as secured by the Constitution. So I think it's still a better way.
Okay.
I'll look at it. Certainly, I still think it's from my perspective and from what I've done. I think to avoid because. To hit the county commissioners in their personal capacity, you're not going to tie up the county's money. You're only going to tie up their personal funds. You'd have to bring it in the name of the county to be able to tie up the county's funds.
That's what I started out with. You sue the county plus the commissioners as agents of the county.
Well, what you also said in their personal capacity.
Of course.
Well,
because if you look at the law says that in their official capacity, they cannot break the law. They cannot violate your rights. Therefore, they had to do it in their personal capacity.
Oh, that's...
They are immune from prosecution in their official capacity, but not in their personal capacity.
But it does, yeah. But you can obviously find government agents, guilty in their official capacity for committing crimes. It doesn't say that. It says that they may not do that. It doesn't say that they can't do it. They do it all the time. In fact, there was the one today about the I was reading it, that the Baltimore Gun Trace Task Force officers. This is what the U.S. attorney. You got a U.S. attorney saying this about a cop. You know these cops are filthy, filthy, dirty. They said that they were both cops and robbers at the same time. So they're charged as police officers. But here, I'm gonna still think it's the better thing to do is to hit their insurance, because none of the actors can claim immunity because it's not applicable. It's against the insurance policy, and they're covered by the insurance. And the problem comes in. For 1 second, the problem comes in if if they're claiming that the actions of let's say the judge are not protected or covered by the insurance, that would be insurance fraud. We know that they're covered by it, but at least that. But what we are able to do, if one of us can get this through, is to name the judges and the prosecutors and cops as witnesses, and then be able to add them to the claim after you get their testimony and can show that they were acting admittedly without any jurisdiction. We have to break the jurisdiction claim to be able to get them in their personal capacity.
I've got a Ninth Circuit appellate case I should send you regarding suing officials in their personal capacity as opposed to official capacity. This came out in November or December, I forget now. It's very recent. So if I can get your email, I'll send that to you. I think it'd be interesting for you.
Yeah, I'll take a look at it, send it over.
What's your email?
The email is markstevens@mail.com. It's on the website.
Oh, okay.
And you can Skype me at FrankRizzo3.
All right. The other thing is most of these counties do not have insurance policies. They are self-insured. So all they have is risk management to limit their financial exposure.
Well, they self-insure, that's true. They don't have bonds anymore. They do self-insure. However, a lot of them do have reinsurance where regular insurance companies, private insurance companies, do reinsure them. And some places like Scottsdale have additional policies to cover multi-million-dollar claims. So it depends on which area you're in and how they're running it. But yes, they do have. That's why I tell people you have to start with risk management and hit that insurance policy. So.
Okay. Well, if you're attacking jurisdiction, the other thing you want to look at is your state statutes. In most states, the statutes say that police are only authorized to investigate traffic unless they see a crime in progress. What is traffic?
I know traffic in one definition. If you want to look at it in a limited sense, I did the same thing 20-something years ago. That traffic is commerce. I get, but that's not the only use. That's not the only way to use that word. It's like person. Person has multiple meanings, and it depends on the context in which you're meaning it. So I don't think that by just using that, well, it's traffic, and isn't well, what does it mean to traffic in cocaine? It means you're buying and selling. That's a limited use of the word, and it doesn't have general application.
Well, traffic also means transportation. That's how it's defined in Washington State, at least. It's also how it's defined in Texas.
Well, you have to, when you're looking at statutes, and I think that's usually a bad thing to do when you're looking at issues of jurisdiction. It's a matter of interpretation, and you have to look at the context that's being used, and one definition from one section of the code may not apply to another section of the code, and it certainly has no application in general. It has just a limited application for that particular code. It's like people saying, Title 28, United States government's a corporation, says so, federal. Well, yes, they do operate as a corporation and a body politic, and then they have other corporation, and that's just the way, to limit liability. But it's no big grand, like, secret knowledge that just the Masons have. Oh, they tricked you. It's not really a government. I have cases from 1790. The United States has always been considered, and all political organizations are always body politic and body corporate. And that's why you have municipal corporations, which is a subdivision of the corporate state. But that...
Agreed. Well, I'm just sharing what we've done in a number of cases in Texas, and we've been very successful with using the traffic argument.
I'd like to see it. Send me the documentation.
Okay. I'll see what I can do about that.
Yeah, Frank Rizzo 3 is the easiest way on Skype. Okay.
All righty. Well, thanks for your time. Just thought I would share a little bit with you.
Well, I appreciate that. Thank you very much. I'm looking forward to seeing the proof of getting the tickets thrown out.
See what I can do for you.
Appreciate it. It's Lewis in Washington, and it's 860. That's Connecticut, not 360. I should have known that. I've made so many calls to Washington that I can say Washington. Let's go. We got another newer call. I don't recognize this, but we do have area code 804. You're live on the No State Project. What's your name? Where you calling from? 804. You're live on the No State Project. What's your name? Where you calling from?
Hi. This is Andrea. Can you hear me?
I can. Where are you calling from, Andrea?
From Richmond, Virginia.
Richmond. What is going on in Richmond today?
I recently... I was recently pulled over in the city of Richmond for an expired registration tag, and he claimed I was also driving without a license. And my issue with that was that I was not operating a motor vehicle for commerce. I was traveling.
Oh, you see. What happens to my Wednesday broadcast, guys? There's no merit to that stuff at all. They make no distinction in their code anymore. 85, 100 years ago, the whole thing about using the streets in the ordinary course had legitimacy, but they all changed. They all changed, and so now that stuff holds no weight. The only sticking point, and I'll give you this, they still call it a privilege tax. And every single definition of privilege tax says it's a tax on a business. So it seems to be right, but it's not. And even if it was, it has proven itself time and 60 years, it has proven itself to be a losing argument because you're talking legal interpretation. You're talking pure issues of law that require no evidence. You and I are always going to lose on pure issues of law. If you're not looking at this from a factual standpoint, something that involves facts, you're going to lose every time. They don't. How about Fangul? That's what they think about us and our opinions. They don't care. They don't give a damn. So, for you and everybody else listening, drop the right to travel stuff because you're not going to get anywhere, especially if you are attacked. So, Fangul to the right to travel stuff. Okay.
So are you okay? So are you of the opinion that it is in someone's best interest to just not say anything, not answer anything, not provide any documentation or information, and request counsel be present at the scene of the stop? Is that what you suggest to prevent this type of thing from occurring?
No, I recommend that you do give the identification and then keep your mouth shut. The only thing you want to say to the police officer is, on advice of counsel, my policy is not to answer questions, and keep your mouth shut. Don't say anything. I suggest giving the ID if you have it, because you run the risk of being killed if you don't. So it's under threat, duress, and coercion. Give it to them. Keep your mouth shut, and more than likely, you'll be able to drive away.
Now, what is my recourse if, I mean, I know every state operates a little bit differently, but do I have any recourse if the officer that placed me under a custodial arrest did not advise me of my rights at that time, and when I did not want to sign the summons, I stated that I would take it, but I did not want to sign it because then I was contracting with him, and I did not want to do that. And he basically, at that point, with his firearm at his side, told me that, under duress, I had to sign those documents or he would impound the vehicle and take me to jail. So
did you
I'm
sign?
trying to find out. Huh?
Did you sign?
I did not put my family name on the document. I am completing this under duress and have advised the officer of that fact.
Did he steal your car and kidnap you?
No, he threatened to do that if I didn't put something down on that summons. And then he also attempted not to give me copies of what I signed. He attempted to take the signed copies and give me the third copy that was unsigned. So it didn't have any of the documentation that I placed on it, at which point I requested that he give me a copy of where I wrote on the paperwork, and he was belligerent about that. He was belligerent about giving me his badge number. Both of the things that the registration that he stopped me for, I explained to him, and I was not required to do this, but I explained to him that it was not my vehicle. And I also gave him the 3 pieces of information that were necessary to verify that I had a valid driver's license. Even though I was not in the process of driving for commerce, I still gave him my family name, my full family name, my address, and my date of birth, which he was able to cross-reference because he put on the summons my driver's license number. So he was able to access that in the database to verify that it was still valid and current. And at that point, he still proceeded to issue that. He could have let me go with a warning, but he chose to be a jackass. I don't know how else to word it.
Well, considering how all the things that you were saying that he's probably heard before and didn't want to hear it, you're lucky he didn't just take the car, bring you in, hold you, and order and suggest to the prosecution and the judge that you be given a psych eval.
Why would I be given a psych eval?
Because
for questioning his authority?
Well, they don't. First of all, they don't like to be questioned. If you do it effectively, like we do, by asking for the evidence their claims are based on. Yes, 1 in 1,000 times we do this, someone's getting threatened with this. Someone in Texas is getting one almost. He's getting ready in 20 minutes. He's going to have one. I got to keep covering this. All of this is under threat, duress, and coercion. All of it. There is no contract. They are not trying to contract with you. So you need to eliminate from your vocabulary today Never bring that stuff up as a serious argument. Never look at the actual facts. He's telling you, if you don't do this, I'm going to hurt you. Not trying to contract with you. So all this traffic, right to travel, Freeman sovereign stuff, we got to say fungal to that. No more. So all this stuff, they think they look at people who do that stuff as domestic terrorists. That's look at the FBI. Sovereigns or sovereign citizens, Freeman types, are considered domestic terrorists and one of the top threats to law enforcement right now. So we want to stay away from that. You want to just stick to challenging the accuser's claims. Okay? So what I would suggest, what I would do is I would file immediately a motion to dismiss, which I do have available, which is based on a lack of evidence to prove the Constitution and Code apply to you just because you're physically in Virginia. And I say physically in Virginia because I'm deliberately making a distinction between the real and the political or the fiction. It's called territorial jurisdiction. They know what that means. They use it for a reason. They think that just because you're physically walking around or just standing doing nothing in Richmond, that means their Constitution applies and gives them jurisdiction. There's not a shred of evidence to support that, and there are even some idiots out there who think that they don't need evidence. And I agree, when you have a prison system and you're a gang of criminals, you don't need evidence. You do everything at the barrel of a gun. You got a prison system. You don't need evidence. I'm saying that they're crooks because, okay, so that's the way we focus our challenge on this. Just ask questions. Don't make affirmative statements. Don't make pure issues of law. Nobody cares what we think the law is. Unless you're a judge or a prosecutor or a cop, nobody gives a damn. So we keep that to ourselves, and it's just not an effective way to defend yourself.
Okay, how do you feel about filing a formal complaint? I mean, I've already verbally complained to his lieutenant about the conduct, or I should say misconduct, at the stop. But I don't know if I should actually submit a formal written complaint.
Yeah. I think it's better to hit, like I mentioned with Lewis in the last call, I think it's better to file the complaint outside the police department so there's not necessarily retaliation from other police officers. So if you're going to file a complaint, I think the best thing to do is file a complaint for damages against the city's insurance because the police officer is covered. So if you have to file another complaint, let it be with the city council. I don't see a complaint with the police department going anywhere. Now, if you file with the city council and they think it has merit and that it should be with the police department, that'll carry a lot more weight if they provide it than if you walk in or you mail it in. Because yours is just going to get thrown thrown away. And if you really upset one of these guys, now you're going to invite into your life what I've had before, and that is a stalker. And yes, James Hahn did stalk me. We were able to prove that in open court. He almost went to jail for it, which would have been nice, but he was threatened with contempt. And so I did prove in the Mesa City Court that he was stalking me, committing a crime. So that's one thing I would keep in mind.
Right. Well, I was considering filing some paperwork that would basically require that I have no further contact with the person, with the officer that placed me under custodial arrest, with him specifically. I certainly don't have a problem based on the conversations I've had with his lieutenant. I feel like his lieutenant is coming from a different headspace, so I don't think that I would have an issue talking with him further. But because of this one individual's conduct, I feel like it is in my best interest because he was operating, from, I think it would be pretty clear to anyone that he was operating as a psychopath. And so I want to make sure that I'm protected. So I feel like the best thing for me to do would be to file some sort of paperwork that, is going to protect me from him. And I realize that a paper is just a piece of paper, but at least if I have that documentation going forward, should something happen, it's at least documented.
Well, that's why, again, if you filed a complaint with the city's insurance, the risk management, you file a complaint with the city council, you do have a record of it. The city council is directly in charge of the mayor. They're in charge of the police department. I just, from my own experience, hell, I was stalked, and I have video proof of this, of where all I did, after just walking into the police department and asking a couple of questions that they couldn't answer. So because they, out of embarrassment, I had to have one of their henchmen try to follow me home. So if you guys haven't seen that, it's a fun video. Just go to markstevens.net and do a search for stalking Mesa PD. But I would get the motion to dismiss in now with the discovery request and start pushing for a dismissal, because one of the best things you can do to go forward with a complaint is to actually have the ticket thrown out. And if it has to go to cross-examination, if you have to go to trial, you can use the officer's cross-examination against him. You'll be able to have his own testimony to use against him. You'll be able to get on the record them impeaching him that he's not even qualified to make legal determinations, which means he wasn't legally qualified, or he wasn't qualified or competent to even approach you, because he wasn't qualified to make the determination he had jurisdiction. Because his own attorney and the city judge are going to both say he's not qualified to make legal determinations. That would be a hell of a thing to have in action against him to show that what he did was reckless.
Right, and I just want to make sure that I'm, I guess, going about this the best way possible. And, I don't have access to an attorney in this area that is going to offer me any sort of educational support in this. And this is the first time I've ever been in this situation before. And I want to make sure that I file the right paperwork. I will definitely take your advice about filing the motion to dismiss, because I thought that it was ridiculous to begin with. And I understand what you're saying about, the word, the specific word choices. And, I was trying to pin this down by pulling up a bunch of definitions in Black's Law Dictionary, because I wanted to make sure that what I was looking at and what I would be coming in with was based on legalese, because I'm not fluent in that language. So I'm coming at this from a completely uneducated perspective, but I'm trying to quickly educate myself so that if I do have to go in there for any extended issue, that I can defend myself. I certainly don't want to have someone else have to defend me and then, be in a position where I am no longer, it appears that I'm no longer competent because I have to have legal counsel. So I don't want to get in that situation.
It's kind of an urban legend that if you get an attorney, you're automatically deemed incompetent, because you have to be competent to even participate in your own defense. So they can have like a Ferretti hearing in California. You have to be declared incompetent. So just having an attorney, hell, you could use that against Donald Trump. He's got a team of attorneys. Doesn't mean he's incompetent, not by that alone. So it sounds like you've really gone into and done some research into this whole Freeman, way of looking at things. And I would stop doing that and look at things critically and question it and look at what's effective and what's not effective. And so I think what's going to be most effective is challenging the arguments and claims the cop is making against you. He's claiming, look, they'll tell you it's called territorial jurisdiction. It's in the name. If you're physically here, our laws apply. And you just want the proof. You need the proof of that, and they have to have a witness or personal knowledge. You have to have personal knowledge of the matters you're testifying to. And
so is that what he meant when he said it doesn't matter whose vehicle it is? If you're driving the vehicle, you're responsible for all the maintenance, tax, whatever on the vehicle? Because I explained to him that the vehicle was not registered to me, and so that should have been a non-issue. The license issue, he was able to access my information. I didn't give him false information. He was able to pull it up, and he was able to verify that it was valid and it was current. So
no, that's not what I mean. What I'm saying is, well, he's saying that the basis of his authority and jurisdiction is that you're physically in Richmond and that their laws apply. So it doesn't matter who owns the vehicle. You are subject to their jurisdiction by virtue of being there. And their laws create obligations on you to do or not do certain things. So whoever owns the vehicle is completely irrelevant as to whether you, in his mind, are obligated by their laws to do or not do certain things. So that's why I attack the foundational claim. Everything he says relies on, the relevance of what he's saying all hinges on whether or not the Constitution applies to you because you're physically in Virginia. If that is not provable, then nothing else is relevant. Well, what does it matter if you didn't have a driver's license? Well, the laws are the laws applicable if the Constitution's not? See, the Constitution, so they like to get it backwards, and they like to say things like, well, the driver's license gives us jury. Is the driver's license evidence the Constitution applies? And they like to claim initially yes, and then you just have to ask them, well, how does that work? How does getting a compulsory driver's license, how does that prove the Constitution, a written instrument from 1776, how does it prove that applies to me and creates an obligation? And they usually drop it after that. So
I need to request that he provide evidence supporting his territorial jurisdiction claim.
Territorial, personam, and subject matter jurisdiction. You want territorial and personal jurisdiction for the police officer to do the stop. You need all three that he's required to have. You know, he needs evidence for all three: personal, subject matter, and territorial. The police officer is on the hook for evidence of that for the court. Okay? So I would file the motion to dismiss and the discovery request.
Okay.
And see, and then take it from there. And I would prep. We do have the Skype chat, the No State Project Skype chat that can help prep. And I also recommend taking this jurisdictional challenge to a city council. It doesn't have to be Richmond. It could be another one. The idea is to get in front of a body of people like you're in court, but with no contempt powers, and ask them these questions. Look, I understand that you operate under the presumption that if I'm physically in Richmond or physically in Virginia, your laws apply and that you have jurisdiction over me. Oh, yeah, okay. And then you follow that up. Do you have any evidence at all to prove that that claim is true, that just because I'm physically here, your laws apply? And that'll help you not only speak and make the challenges, but you'll be able to deal with the stupid responses that are going to come out of their mouths.
How do you handle situations, should, for whatever reason, the judge not see things from my perspective and attempt to derive funds from me when I'm unemployed? What are my options as far as making them liable for any funds that they charge me for?
Well, that's going to be a claim against the city's insurance. As far as having the judge see things the way you do, you want to always ask leading questions. You want to object and ask leading questions. Now, a leading question, of course, as I mention all the time, is a question that has the information in the question. It's not open-ended for the person answering to just give a narrative. He's limited in what he can say to usually just yes or no. And so to get him to understand or see things the same way or agree, one of the examples is they'll let the prosecutor argue without evidence. They'll allow the prosecution to say, make a legal claim against you that because you're physically in Virginia, the laws apply. That's a legal conclusion that needs to be based on facts. And they'll turn around and say the prosecution doesn't have to do that. Now, for you to be able to get the judge on the same page, that you really are not allowed to do that, you make an objection and says, you're allowing the prosecution to argue without evidence. Okay, do I get to make legal claims against them without evidence? And he'll bring you, that's the way of bringing him back. And so his response will be, absolutely, you can't do that. Why can the prosecutor do it, but I can't? Does that look fair to you? Why are you allowing him to do it? So that's how we do it. We always do it through an objection and asking leading questions such as that. But I'm really jammed for time. And I know I got to make up some time because I had a tech issue. But what I would suggest is getting on the Skype chat and going to the website, because I got a ton of more information. Look at the archives and the articles, because we talk about court procedure all the time. And feel free to call in to the Saturday show where we have a lot more time.
Okay. Thank you.
I appreciate the call. Andrea in Richmond. We're going to get to another newer caller. I'm probably going to be our last caller, so I'm going to go a little bit over to make up for the tech issue. We got area code 973. You're live on the No State Project. What's your name? Where you calling from?
Hi, Steve. Hi, Mark. My name is Ari. I'm calling from New Jersey, and interestingly enough, I had a first meeting in Fort Lee Court yesterday. And I know you are familiar with that particular courtroom.
I have not been to court personally in New Jersey. I've only helped people with court cases in New Jersey.
You didn't have a court case in Fort Lee, New Jersey?
Me? No.
Yeah.
No, I've not had any cases with me as the defendant in New Jersey. I've had in New York, where I'm from Long Island. So I've had a number of cases there, or complaints, but not New Jersey.
I got you. Well, maybe that's my misunderstanding. However, from my personal opinion, from my personal experience, I should say, I have used a notice of intention to sue, notice of this pendants, where the mayor, the city council, every one of them was named as a defendant in a notice. The actual lawsuit was not filed, but the moment I served them with a notice, my experience was that the judge threw the case out and actually transferred to another town. And that judge was served with the same notice. He transferred to another town, and from there the case just died. I never had they never called me to show up, never scheduled a hearing, nothing. So.
Wow, so two examples of Liz Pendens in the same show. And for those who, and I'll have this in the video, Liz Pendens is a written notice that a lawsuit's been filed concerning real estate involving either the title to the property or a claimed ownership interest in it. The notice is usually filed in the county land records office. Recording a Liz Pendens against a piece of property alerts a potential purchaser or lender that the property's title is in question, which makes the property less attractive to a buyer or lender. Liz pending is Latin for suit pending, which this may refer to any pending lawsuit or to a specific situation with a public notice of litigation that has been recorded in the same location where the title of real property has been recorded. So you're using a Liz Pendens, but it's not regarding any kind of real estate.
That's correct.
And you're having success. And you're having success with this. So, are you able to send me the documentation that because I know if you file a lawsuit against the judge, they won't even remove the judge. They could say you could have 1 million lawsuits against the judge. It's not a reason to recuse a judge. So I know that is like black letter law, and they don't budge from that because anybody could just file a lawsuit.
No, I did not name the judge as a defendant at all. In fact, the judge and I had a very good rapport and respect to each other and no issues whatsoever. So the prosecutor was the one that had the issues and, of course, didn't want to dismiss the suit. But what happened was I spent quite a few years in investment banking, and I'm familiar how the bonding and municipalities operate with that regard. So when you send them a notice to the township itself, naming the mayor and so forth, that the lawsuit is about to be filed, and you list certain violations that the reasoning for the lawsuit, they do not wish to engage in this particular activity where their credit rating will drop. And the reason for that is because once the lawsuit is filed, they have to report it, including their insurance carriers, and their credit rating drops, and they have problem obtaining financing for their project.
Well, theoretically, yes. Theoretically, you're right, but is that something that they concern themselves with? Because they get hit with lawsuits all the time, and the idea that it's under a lis pendens, it doesn't seem like it's even necessary to do that part of it, because it only applies to real property, where if there's a dispute as to the title of property, it doesn't seem to have any application at all in a personal damages lawsuit. Why even bother?
Well, you want to call it this pendency. You call it notice of pendency of a lawsuit or a suit. It regardless of what you call it, it's still giving them notice. And under their rules, you're required to give them notice prior to filing any kind of lawsuit against a governmental entity. And so that's why you may call it a notice of pendency of action, and that's about it. But what it does, basically, it gets their attention, because the judge is on the payroll of the town. And they get their budget set for the court. The judge gets the paycheck from the town, from the council members, and so is the prosecutor. So you hit them in their credit rating. That's their main concern. They'd rather go and get another 100 guys who don't know what to do with this than deal with this issue. Well,
and I certainly appreciate that, and like to know that you have some evidence that you've had success with that, because that's why we're going and using the claim against the insurance company. Maybe it's something we have to file ahead of time. But as far as yes, you do have to give them notice. You're also supposed to do everything reasonably expected to resolve the conflict prior to filing it. So you could have it thrown out just on the clean hands doctrine, even if you have a legitimate case. But I'm completely out of time. I would like to see the proof of this. So if you and Lewis, who are both saying that you've had success with this, if you guys can send me some documentation to show that they are doing that they did transfer because you will have a paper trail if they've transferred the case, the complaint.
Oh, yeah, I have it.
Yeah, well,
I have it.
Scan it and send it to me.
So, very good, I will.
Sounds good. Yeah, I appreciate it. I wish I had more time, but it was one of those days, and so I got to let you go. But hey, I'm looking forward to seeing it. Remember, my email is markstevens@mail.com, and you can also drop it at frankrizzo3 on Skype, all right?
Sounds good.
All right, appreciate the call.
Thank you for talking to me.
Yeah, thanks, I appreciate the call. Ari in Ari in New Jersey. New Jersey there. I actually saw, the first time I saw Iron Maiden was back in 1988, and it was at the Meadowlands. So, I would, that was, and I saw The Who in 1989. It was supposed to be the big farewell. We know how that worked out. They usually don't. But this has been episode 48 of the No State Project commercial-free, January 24, 2018. Libertopia 2018 is going to be in San Diego again. Libertopia.org is where you can get that. I will have, I'm sorry if I missed anybody here today, and I'll get this up at markstevens.net. So if we missed anybody, Saturday broadcast again, the LRN broadcast, and we'll get to everyone there. Look for the next couple videos that are going to be the Stephen Myrie flagrant prosecutorial misconduct, and he's done it multiple times. Imagine over 600 pages worth of documents he failed to give, and you've got to see his stupid excuses. The things that he said when he was nailed. You can't believe, and unfortunately, the judge didn't think, even though the judge says that it was flagrant, didn't think it was intentional. How do you flagrantly commit misconduct of over 650 documents and have it not be intentional? And so the judge, I'll go through this. This was. This guy, so what we're going to do is I'll have the Stephen Myrie tyranny spotlight. We'll finally get that. And, of course, the Cheril Hardy, the Tarrant County judge, where right now Bao is going in front of that psychiatrist. I gave his name, Dr. Norman, Dr. Barry. I should have wrote it down, but Dr. Barry Norman doing that right now. So she'll be in the Tyranny Spotlight also. So unfortunately, we are at a time. Like I said, my name is Mark Stevens. The website is markstevens.net. If you've got evidence like this, like what Lewis and Ari saying, hey, I'd love to see it. And if you disagree with anything that was on the broadcast today, give me a, call into a live broadcast and present the evidence, or where I got my logic all tied up in knots, because I'd love to hear it. I do value dissent here on the show, because it's about the truth, not just maintaining a certain narrative, regardless of what some people may think. I do conform my behavior and belief to the evidence, not the other way around. Again, my name is Mark Stevens. The website, of course, markstevens.net. So till next time, salut.